Good morning, everybody. Got a few more folks making it in from the waiting room. All right. I think I'm going to go ahead and get started while we're waiting for those last couple folks to join us. And I'm going to start like I usually do by welcoming you, of course, but also with some Zoom housekeeping tips. I want to start by asking everybody to remain muted while we're in the Zoom today, just to cut down on background noise. You are welcome to unmute yourself to ask a question if you would like to do that. But otherwise, if you could stay muted, that would be great. I just put a message into the chat, so that might be blinking for you, the notification for your chat button. And that is the best way to ask questions during our Q&A today. And if we don't get to your questions today, or if you think of new ones that you want us to cover in the future, the message I just put into the chat tells you how to send those questions to us in advance of each week's Zoom. And the message also includes a link to our YouTube channel where we post the videos for each week, usually within a couple of days of each week's Q&A. Although that reminds me that I don't think we've posted the one from last week. So Chelsea, pretty please remind me when we're done today to get that one up. So bear with me here as I get my brain back on track. Oh, I'm just going to keep going through our normal housekeeping stuff. We are here to give general information, not legal advice. We tell you guys that same thing every week, but we do need to just remind everybody that that's the case. Sometimes the questions that we get are very, very, very specific or paragraphs long or contain excerpts of your governing documents. And if any of those things is true about your question, you're probably asking us to answer something that's too specific for this context. And so we try to cover those topics generally when we can, but otherwise keep in mind that we're here just to speak generally about these issues, not give legal advice for any particular community. Similarly, the chat function is not intended for legal commentary or discussion. It's been a while since I've had to give that reminder. I think we are usually pretty well behaved in the chat. So please do limit that to posting questions or clarification of your questions when we're talking. And if you do have a question that you didn't think to send us in advance, you're welcome to pop that into the chat for today. And if we have time after we go through the prepared questions, then we'll get to what we can from the chat. We have been telling everybody for a while about a Senate bill that is being considered by our legislature this year. It's still under consideration. It's looking very likely to pass. And it is something that we would really like folks to consider contacting their legislators in opposition to this bill. And so this is engrossed Second Senate Bill 5686, so E2SSB 5686. And the topic of the bill is expanding and funding the foreclosure mediation program. Previously, the foreclosure mediation program in Washington state only applied to non-judicial foreclosures conducted by mortgage lenders. This bill not only seeks to expand that program to require community associations to go through this process, it also expands it to include judicial foreclosures, meaning foreclosures that we're doing via the courts, which is how the vast majority of association foreclosures are done. The bill has just sort of expanded considerably over the legislative session. So not only does it require associations to participate in the state mandated mediation program, it requires the association to treat any of its legal fees, any expenses that it incurs as a result of that, as a common expense rather than being able to assess those fees to the delinquent owner, as is currently the case. It also adds another step before you even get to the mediation. So what happens is when an owner contacts a housing counselor, the housing counselor contacts the association, and you're required to participate in something called a meet and confer. That language is, from the original mediation statute. And I think the intent behind the original statute was to bring borrowers and mortgage lenders together and force them to have a conversation with people who have the authority to make decisions about these things. So that requirement has now been expanded to include associations as well. So there's the meet and confer requirement, wherein, again, legal fees have to be treated as a common expense, not collectible from the delinquent owner. After the meet and confer process, then there can also be a requirement to go through the mediation process. And only after all that stuff has been done can you then restart or resume whatever collection action you were trying to take against the delinquent owner. It also has now expanded to require that associations notify all owners of any delinquency within a maximum of 30 days of the delinquency arising, which honestly, I don't think that's that bad. Most of our clients, if somebody misses a payment, you send them a notice within, a couple weeks, 30 days, usually, or a month at the most. The problem here is not only do you have to send them written notice of their delinquency, you have to include a copy of the statutory pre-foreclosure notice of delinquency, which again, you're supposed to be doing already, so this shouldn't be that big of a deal. But until you comply with that requirement, you are not allowed to pass on any collections related costs to the unit owner, to the delinquent owner, in excess of $10 for an admin fee to send the letter. So part of why this becomes an issue is because in the previous iteration of the statute where we negotiated to allow an association that didn't know about the statutory pre-foreclosure notice of delinquency, for example, because there's a lot of small HOAs in Washington state that they're not members of CAI. They don't come to these Q&As. They don't work with an attorney. They don't even know that these things are requirements. The current statute around that notice allows the attorney to send the notice for the association when an account is referred to our office if the association failed to send it themselves. This removes that option from the table and caps your ability to recover any collections costs at a maximum of $10 until you've complied with this notice as an association. And so it sets up some statutory conflicts because the one statute says one thing and then this statute says another thing. It also does not have any provision in it to toll the statute of limitations, to basically put the statute of limitations on hold during however long it takes for the meet and confer and mediation process to unfold. So we think in total, what this does is it slows the collections process down pretty dramatically without a significant benefit to the delinquent homeowner, and certainly with no benefit to the associations. I think the mediation and meet and confer process was created for banks and borrowers that don't talk to each other all the time. And community associations are different. Homeowners can come to a board meeting. They can email their board members. They can contact the manager. Often those things have already happened by the time an account is referred to our office. And so all of that is to say, I think this bill is really cumbersome. It's going to increase costs for community associations and make collection of delinquent assessments even more difficult than it already is. And so if you have the time and the bandwidth and the willingness, if you look up E2SSB 5686 and contact your legislator and encourage them to vote against it, we would really appreciate that. I'm not sure how successful those efforts are going to be. I think it is likely to pass, but we're doing what we can to either slow it down or stop it if it's possible. I don't want to take too much more time on that. If you guys have questions about it, you're more than welcome to pop them into the chat and we can cover them later. The last announcement that we have is that the WSCAI annual conference is coming up. Believe it or not, it's next week. So that is April 24th through the 26th. It's at the Hilton Seattle Airport and Conference Center. I just put a link in the chat to the event for the annual conference. We are going to be there on Friday. Our firm is doing 2 different presentations. We've got a booth set up at the trade show. So if you guys are going to be there, please come by the booth and say hi to us. And if you don't know what it is or you haven't bought a ticket yet, consider doing that. I just put that link into the chat. It looks like there's a question in the chat about Senate Bill 5686. And the question is, does it apply only to delinquent assessments or would it also apply to delinquent utility bills, et cetera? Assessments as defined by the common interest statutes includes all valid charges on an owner's account. So the only distinction, the only time where this matters is that for the purposes of filing a foreclosure lawsuit, you have to meet a threshold balance due that only includes, or only in the calculation, you're only allowed to consider assessments, any assessments charged and any payments made against the account. And if you don't, if that threshold balance due isn't met, it's $2,000, then you can't file a foreclosure lawsuit. But this applies no matter what, because even though it talks about, or it's entitled foreclosure mediation program, owners who contact housing counselors can take advantage of this process, even if they're not already in foreclosure. And that part I actually understand and agree with, because the whole point of it is to try to help people avoid losing their homes in foreclosure. And I'm very supportive of that effort generally. I just think that this particular bill is going to, it's going to hurt, it's going to cause more problems than it solves. That's what I think. So I'm going to go ahead and move on to our first question that was submitted in advance. And then as you guys have additional questions or requests for clarification for us, you're welcome to pop those into the chat. The first question is this: can an HOA process a foreclosure on a homeowner without previously having a lien on the property? And the short answer to this question is no, because when you file a foreclosure lawsuit, you are foreclosing on a lien. So if there's no lien, then there's nothing to foreclose. That's the short answer. There is more complexity to this question, because communities that have a statutory lien, which is everybody but HOA Act communities, may be able to foreclose that statutory lien rather than recording a paper lien with the county. And I'm using air quotes with the word paper because we actually record everything electronically now. So there's very little actual paper anymore in the process. So if you are an old Act condo, a new Act condo, or a Wakaiowa community, your governing statute basically says that from the time a delinquency arises, so does a statutory lien. And I think it's kind of like this, magical is not the right word, right? Because there isn't a lien that gets recorded. It doesn't mean that some actual lien is recorded with the county records. It just means that in terms of lien priority, in terms of the association's interest in the property, a lien exists legally, even if it hasn't been recorded with the county. HOA Act communities do not have a statutory lien. Not only that, the HOA Act does not provide for the authority to record a lien unless that authority is contained in your recorded governing documents. So if you are an HOA Act community, and if your CC&Rs are silent on the authority to record a lien, not only do you not have lien priority, not only do you not have a statutory lien, not only do you not have a resale certificate requirement, which theoretically means that a property can be sold without anybody knowing that there's an HOA interest in the property. If you don't have the right to record a lien in your recorded documents, you may not actually have the right to record a lien at all. That's a whole different sort of rabbit hole that we could go down. So the issue with the statutory or automatic liens that I'm talking about is that depending on the judge, you might have to do a lot of educating on why it is okay to try to foreclose that, imaginary statutory lien that I'm talking about versus foreclosing a lien that's actually recorded with the county. And I also think there are a lot of other reasons to record a lien, to actually record a lien with the county, even if you do have a statutory lien. So if a delinquency is old enough or big enough, and there's no bright line rule that I can give you that's applicable for every community, you should probably record a lien. If you're wondering whether that is true for your particular community or for any specific delinquency in your community, then you should be consulting with your association attorney about whether a lien should be recorded in a specific instance, and also what your process should look like generally when it comes to delinquencies and liens. Jennifer, did you have anything you wanted to add on that one?
No, I think you covered it.
Okay.
So our next question. A member has requested to see our financial records to see where their dues are going. I was in the process of redacting any names that showed on our bank statements for deposits in the first 3 years we were formed. It's a lot of work. Is it necessary to redact names for deposits? What exactly needs to be redacted? So the authority or the statutory information, I'm only going to refer to Kiowa, but in, I believe it was 2021, the legislature amended all community association statutes to include language regarding records, what must be retained, what can be redacted. So for Ukiah communities, it's 6490, 495, sub 3, sub H. So what this means basically is that if your documents, if any requested records have things like specific account numbers, maybe names, that depends, those can probably be redacted. Please note that 6490, 495, sub 1, sub E only requires financial statements to be kept for 7 years. If you have any that are older than 7 years, after the request is complete, they can be destroyed. So you can also produce in batches, so you have less upfront time and they get records that they want and maybe will say, okay, I'm good. But what this all means is that specific information regarding a particular unit may be able to be redacted. But if you are redacting names of vendors or producing records of expenses, we don't know why those particular names would need to be redacted. So, if you're paying members for any specific reason, those would need to be disclosed in some form. You might want to consult with your association attorney to see what redacting is necessary. If an owner would be satisfied with an expense report, you may not need bank statements. However, owners are allowed to see any checks written on the association's accounts. So, and to whom those checks were written. So it depends on what information you want to redact. If there's a specific exemption for that under the statute, and then also, does it make sense? So it may make it easier, it may make it harder. It really depends. But if it's just vendor names, there's no reason to redact that. If it's individual owner names, maybe. Valerie, did you want to add anything to that?
Yeah, I mean, I think the nutshell is you might be redacting a lot more than you actually need to redact, because the owners might be entitled to see a lot more information than you realize. And that's where consulting with your association attorney would come in.
Okay, so this was a 2-part question. So the next part, 6490, 495 sub 5 states, except as provided in section B of this subsection, an association may charge a reasonable fee for producing and providing copies of any records under this section and for supervising the unit owner's inspection. As a volunteer board member, can we charge for the time spent redacting documents? If I understand that if we hired someone to do it, yes, but if we do it ourselves, does the law allow us to charge for our time and the money go toward the association, not the volunteer? So the answer to this particular question is yes. The costs have to be reasonable. But owners who are requesting records are responsible for the reasonable cost of compiling and redacting records. Then the question is, how do you determine a reasonable rate? So we've had clients do redactions by themselves and charge probably between, I'd say, $20, $25, $30 an hour for researching and compiling and redacting records. That probably will be reasonable. If someone wants to try and state that, well, our manager charges $100 an hour and we're doing this so the manager doesn't have to, you have a contractual obligation to pay the manager the $100 an hour. It doesn't make sense for a volunteer homeowner to charge that much for compiling records. So honestly, reasonable is in the view of a judge, 7 to 9 a year, 7 to 9 months a year after the owner contests. So we think that $25, $30, somewhere in that range is probably reasonable. It hasn't been challenged yet. We do recommend that our clients don't become the test case because bad facts make bad law. But there's no guidance here. Valerie, did you have anything to add?
Yeah, I think, a couple of different things. Number one, this is where consulting with your attorney about what needs to be redacted and what doesn't also matters. Because if you spend 100 hours redacting stuff that, you didn't really need to redact anyways, and you try to charge the owner for that time, then that's not going to end well for you, right? The other thing that I think makes a lot of sense and that we tell our clients to do anytime they are considering passing on records related costs to the unit owner, to the requesting owner, is you tell the owner what the cost is going to be ahead of time and get their agreement to pay that amount in advance, rather than doing all the work and then slapping them with a bill that they had no idea they were going to incur. So I think those are things that can help you not become the test case, as Jennifer is saying, because that's definitely not something that you want. So another thing that happens often is sometimes owners will submit these records requests that either intentionally or unintentionally are incredibly voluminous. They don't really understand what it is that they're asking for. And if you go back to the owner and say, okay, I've got your request, this is the amount of time that I think it's going to take, and this is the number of dollars I think that's going to result in you being charged by the association. Do you want to narrow your request down a little bit? Sometimes they will do that in response because they may not have any idea what exactly it is that they're asking for. And then one other comment that I'll offer is that these kinds of scenarios are things that I think are probably part of the basis for why a lot of our clients are starting to make more and more association documents available to their homeowners online. So a lot of our clients will have like closed, password protected websites that only their owners have access to. And they are including not just things like board meeting minutes and governing documents, but also things like maybe their monthly financial reports and their annual financials and a copy of the reserve study. And a lot of the documents that are the ones that are most likely and most common to be requested by the homeowners, they're including those on a website like this to sort of mitigate and cut down on the number of owner requests for documents that they get. So that's something you can consider, that's a more general comment, not necessarily directly responsive to the question. All right, I'm going to keep us moving through the questions with the next one, which is when updating the CC&Rs for 6490, it was mentioned in the past that one would not have to include the declaration pages, and the declaration part is in quotes, in the update. If this is the case, why is that true? Do we not need declaration info in our updated CC&Rs? Will 6490 take the place of the declaration? And I think half of the discussion that we had around this question was that we don't really understand the question. And so if the person who submitted this question would like to give us some clarification in the chat while we're talking, feel free to do that. I think what you're probably asking about is the recitals page. So every time you record an amendment to your declaration or CC&Rs, which those two terms are used interchangeably, and terminology matters here. Anytime you record an amendment to those, you're supposed to have a recitals page that refers to all of the previous amendments and the original recorded declaration. And there's nothing in the new WCAI for All statute that changes that. So if you are a condominium and your original declaration was recorded in 1995 and you've had 3 amendments since then, each of those amendments should have referred to the recording number for the original declaration and each of the previous amendments as well. And any restatement or amendment that you record now in anticipation of Kiowa for All, or in a year or two, also needs to, in the recitals page, refer to those previous recorded documents, the original declaration recording number and the recording numbers for the amendments recorded since then. So if I might be answering your actual question, I might have guessed right. And if I did, then that's great. If not, feel free to put some clarification into the chat for us or send an email so that we can clarify more next week. This question did also remind me that it's probably helpful every now and then to do a really quick primer on terminology and what our documents are called and why it matters to use the correct terminology. Because each document does different things and carries different weight. So we have a lot of clients that will refer to all of their documents collectively as the bylaws. And your bylaws are a specific document that are supposed to contain a specific subset of information. Your declaration, also referred to as the CC&Rs, the covenants, conditions, and restrictions, that's a specific document that contains specific sets of information. And so it matters that you understand what each of these documents contains and how they're different from one another. So your articles of incorporation are the document that was filed with the Secretary of State to create the nonprofit corporation for your association. And side note, if you are not yet incorporated as a common interest community, when Kiowa for All hits, you are going to have to fix that. You're going to have to be incorporated in one form or another. There's a lot of reasons to be incorporated before then. Every client that asks me if it's a good idea for them to incorporate, I tell them yes. And if you want more information on why, then you can send in a question for a future Q&A and we'll cover that then. That's the articles of incorporation. Usually those are limited to information about the corporate structure of the association. Who's the registered agent? What kind of corporation is it? You know, what's the name of the association? That kind of thing. Every once in a while, there's more information in there than what should be. And it's important to know whether that is the case because the articles do have binding authority on the association. The original declaration of conditions, covenants, restrictions, and blah, 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 CC&Rs, the original declaration of the CC&Rs is the original recorded document that sets forth what property is included in the association and that talks about the rights and the obligations of the association and the homeowners that are members of the community. So that's where things like rental restrictions belong. Can you have pets? Are you not allowed to have pets? How much are the assessments and what is the rate of interest that the association can charge if an owner is delinquent? Is there an alternative dispute resolution provision? Are people banned from smoking in their units or are they allowed to smoke in their units? Can people raise poultry on their lot in this HOA or is poultry banned? That's where you find those types of rights and restrictions, okay? Rights and restrictions are related to financial obligations and use of the property. Your bylaws and the declaration is recorded. Any amendment to the declaration has to be recorded. Any amendment to the declaration has to be voted on by the ownership. The bylaws are usually, but not always, not recorded. Sometimes they require a vote of the owners to amend. Sometimes they can be amended by a vote of the board only. And the bylaws are typically supposed to contain information about procedure and how you run things in your community. That's going to be where you find things like your annual meeting information and quorum and the number of board members and, you know, procedures for calling a meeting, a special meeting, things like that. We see people put stuff in their bylaws all the time that don't belong there. Stuff that doesn't belong there. So you can't put a rental restriction in the bylaws because that's not enforceable. So that's your document that's like, how are we going to govern ourselves as a corporation and the people within it? That's the procedural document. And then there are other documents that every community may or may may not have, including things like rules and regulations or a collections policy and enforcement policy, things like that. So terminology matters. Don't use the word bylaws to describe all the documents that govern your community, and do your best to learn the difference between the different types of documents. if anybody here thinks that it would be helpful to have a little bit of a longer kind of class about this stuff, send us an email at the email address that's in the chat, and we will dedicate, a chunk of one of our future Q&As to a little bit more in-depth education on this stuff. So I think I'm going to stop ranting on that one now and let Jennifer take us to the next question.
So the next question, I'm going to condense this a bit. It was rather long. There are very few willing and qualified board member candidates who are willing to serve on boards. Most newly elected board members are simply serving because no one else wants to do it. Most of these board members don't understand what their responsibilities are, so they're unresponsive, or they may have a personal agenda that they want to promote when they're on the board. Regardless, because they run unopposed, they end up automatically being elected. So this individual remembers that Ken said on a past Zoom that it might be wise to put yes and no checkboxes on ballots by each name to help associations avoid having only the problem candidates automatically seated in the open position. Is this true, and is this acceptable? So the answer is, it depends on what's in the governing documents. If the documents state that a majority of quorum must approve any particular vote, then it is possible that any individual running for the board who did not get a majority of quorum would not be elected. A board member must be elected by the owners or appointed by the board. For an election, you can require that a majority of the votes cast be in favor. So as an example, as long as you have a quorum and a majority of owners vote yes for a particular candidate, that candidate is elected. If a majority or less than a majority vote yes, then that individual is not elected. So if only one person is voting and you have a yes or no ballot, there are more no votes than yes votes. You can just leave that position vacant. And this particular procedure was used, Ken can tell this story much better than I can, for several years to keep a particular individual off of a board who was particularly problematic until the community got tired of dealing with them and just let him be on the board. So it is possible to prevent someone from being on the board requiring a majority vote approval, but it must be in your governing documents to be effective. Valerie, did you have anything to add?
No, I think that's everything. Our next question is, in a community with an open meeting requirement, if the ARC committee, and that's Architectural Review Committee for anyone who doesn't know, if the ARC committee consists of only 2 board members, do they need to hold official meetings to make all ARC decisions? Yes. Yes, they do. If they are exercising the power of the board and making decisions, then they need to have open meetings. If you look at RCW 6490-445 subsection 2A, you will see that committees that are exercising the power of the board have the same rules and requirements in terms of having open meetings. So if the board members are making decisions and approving or rejecting architectural submissions, then they have to have open board meetings and make those decisions at open board meetings. The statute does require meeting minutes and open meetings for committees that are exercising board authority. If this committee was only making advisory recommendations to the board, and then the board itself was voting on those ARC applications, then it might be possible for the committee, when all it's doing is formulating recommendations to the board, it might be possible for those meetings to not be open. But I would like to be really careful and tell you all to take that with a very, very large grain of salt, because the trajectory and changes in our governing statutes and there has demonstrated a very, very clear legislative intent over the last number of years, and in particular going forward. And the legislative intent is that association actions, board decisions should be made at open meetings because there is value in that transparency. The legislature has made it really clear that it wants the association's business to be done not behind closed doors, but with open doors so that the ownership can observe and understand what all is going on. So I don't think this question was submitted with an intent to like circumvent these open meeting requirements. I think a lot of us just have genuine questions about how to implement these open meeting requirements, especially if you're in a community where this is a new thing for you, right? I think whenever you're in doubt, if you're ever even just the smallest bit in doubt, do it in an open meeting. The legislature is moving community associations away from doing business by email, doing business via unanimous written consent outside of a board meeting. And I know that we've got the January 1, 2028 date in mind for when WSCAI for All is going to take effect. But you all should be aware that the meetings provisions within WSCAI have been under negotiation this year as part of the WSCAI trailer bill is what we're calling it. And it is very, very likely going to pass. Actually, it has passed, and it's likely to be signed by the governor in the next couple of weeks. And that bill is going to make the meetings provisions applicable to everybody early, January 1 of 2026. So you don't have 3 or 2.5 years to get used to this idea of open meeting requirements. You've got to get with the program quicker than that, because we're all going to be operating with open board meetings, open committee meetings, etc., in less than a year, because that part is going to take effect in January of 2026. So I think that covers that question. And Jennifer, if you have anything to add, please feel free.
I think you covered it.
Okay.
So our next question, regarding reserve account control, we are a Ukiah community and wanted to ask for clarification on RCW 6490-535 when it states that any reserve account must be under the direct control of the board and the board is responsible for administering the reserve account. What does this mean exactly? In our situation, we use a community management company to manage our finances, but they only have access to any accounts and to use the accounts as they are intended for. The board does have read-only access, but only one board member can be assigned that role in their accounting system. Does this meet the requirements? If not, do you have suggestions on how we rectify this? So there has been no case law to interpret the statute, and we don't know what the legislative intent is. This particular language dates back to the 1990 Condominium Act, so the new act. The questions to look at: does the board direct the management company on how much should be distributed to and from the reserve account? Does any action with the reserve account require the approval and or signature of at least 2 board members? Does the board direct the management company when money is released from the reserve account? Does the board make decisions about investments? So if the management company is acting as the agent for the association, it's probably okay. But we don't have clear guidance until there is a court case or the legislature amends the statute. And Ken noted that a strict reading would imply that the board must be signers on the account directly with the bank, and any check drawing money out requires 2 signatures. That gets to be really onerous for the association, and most management company contracts require that the association use them for all accounting purposes. So we don't know. And as long as your procedures are reasonable, the board has access to view and is directing the association's agents on how the money is put in the account and how it's used. That's probably okay. There have been particular instances recently of either a manager or board members taking money out of reserve accounts illegally. So Ukiah also requires associations to have fidelity insurance to protect all funds of the association from bad acts of either managers or board members. We recommend that all associations have fidelity insurance that would cover scams from third parties, because that's been a problem. But make sure you have fidelity insurance. Make sure you're keeping tabs of your reserve accounts. If you have a management contract that requires you to use them, make sure that you are directing the management company on what to do, and you're probably going to be fine. Valerie, did you have anything to add to that?
Yeah, one thing that I will add, noticing in the question that they said their management company, the board has read-only access to the accounts, but only one board member can be assigned that role in the management company accounting software. That's not the only way that you can view your bank account activity. So one thing that should be happening is that every month your bank statements should be provided to, at a minimum, the board treasurer, if not the board as a whole, in your financial statements from your community manager. So you should, whichever board member is designated that online access, that read-only access to the accounts, should also be sort of spot checking to make sure that the paper statements, PDF, whatever that you guys are being given matches up with what you can see online, so that there's no indication of, sort of fraud or alteration of those documents. And let's be clear, although we have had situations where a client has had money stolen either by a manager or by a board member, it is exceedingly rare. Most of the managers and the board members we know are doing their very best to act in the best interest of the association. It is rare, but we do think that as board members, you do have an obligation to be directly monitoring the finances of the association. And so part of how you do that is you look at the stuff your manager sends you every month. I know because I get managers saying, I'm doing my board packet for the month. Can you send me the monthly update? Your managers are for the most part providing you guys with a whole packet in advance of your board meeting each month, or maybe towards the beginning of each month, that's got all the invoices that were paid for last month or that need to be approved to be paid for this month, your bank account statements, maybe your balance sheet, maybe your delinquency report, all that stuff. Look at what your manager sends you so that you can prove to a court down the line, should it ever be an issue, that you're actually meeting your duty of care as board members to be directly monitoring the finances of the association. So Jennifer's right. There is no case law that interprets what exactly does it mean that the account is under the direct control of the board. But I'll tell you what it doesn't mean. It doesn't mean your manager is the one that administers all of it. You don't look at the reports that they send you every month, and a year and a half goes by before you notice that money has been missing from the account over a period of time, right? It definitely doesn't mean that. And I think your chances of demonstrating to a court that the account was under your direct control, even if you're not the one that has the technical online access like your manager does, the chances of successfully demonstrating direct control to a court go up dramatically if you are actively and frequently monitoring the financial information that is provided to you from those accounts. So I'm going to go ahead and move us on to the next question. We recently had to table a $65,000 special assessment ratification, and we would like to try again. We still need to give 14 days notice, right? Also, are there any mandates regarding how we allocate the amounts and the due dates? And how do we handle non-payment by owners? Finally, can we leave the last payment as a range of dollar amounts, since we do not know the exact amount until further into our reclad project? So I'm a little curious about what it means that you had to table the ratification. And I'll start there, because special assessments, the board gets to decide on the amount and the timing of a special assessment. The board is the group that is tasked with that governance piece. You guys are the ones that are reviewing the cost of the reclad project, the cost of any project management, any management costs that might be associated with that or with a special assessment. And you are the ones that put together the special assessment budget, and you vote on it and adopt it and send that proposal out to the ownership. The owners just get to reject or ratify the special assessment budget. So if I don't know what it means that you had to table it, whether it's just that you didn't have enough agreement among you all as board members, or if you got a lot of pushback from your ownership, or if your ownership rejected it. I'm not sure what that means. But I do want to clarify that the board is the group that has the authority to make a decision on a special assessment amount. The ownership just has the ability to ratify or not ratify that special assessment amount. And we do understand that communities with special assessments, especially the bigger that they get, the more pushback you end up getting from your ownership. And what I would say is that even in a scenario like that, you hold a vote, have a ratification meeting and hold a vote at that meeting. That way your owners get to either reject the special assessment or it's ratified. And to be clear, and to answer your question, you do still have to give 14 days notice anytime you are sending out either a regular budget or a special assessment for ratification by the ownership. The statute requires no less than 14 days notice and no more than 50 days notice. And in the special assessment documentation that you send to the ownership, you have to give the amount due per unit, when the assessments are due, the projected income and expense by category. So if it's literally just one project, it's the strip and reclad of your building, that's going to be a real simple budget, right? But you do have to tell the ownership what exactly the money is going to be used for. And you do have to give them a specific amount. You can't adopt a special assessment that's like $60,000 to $65,000. You have to pick an amount and assess that amount to the ownership. So what I would tell a client that is trying to decide exactly how to set the special assessment amount is you figure out the actual amount that you know you are going to have to pay for the project. And then you add some margin because A, the project cost could increase. There might be unexpected expenses between now and completion. And B, there might be some owners who don't pay. And you have to assess enough that even notwithstanding those two variables, you have enough to pay your contractor when those payments are due. Okay. So if the reclad project itself is $65,000, that's what you know right now, then I think your special assessment probably needs to be more like $70,000 or $75,000, which maybe isn't the news that you want to hear. But that way you're building in some margin for any unexpected costs that might arise before the project is over, and or for the eventuality of if there are owners that end up not being able to pay the entire special assessment. You do have some flexibility as to when different amounts are due and how much is due at each due date, but you do have to specify your actual dollar amount, like I said, and when it's due so that you know if and when a payment is delinquent. You cannot offer two or more payment options without stating which one is the default option. So for example, owners can pay upfront, $7,000 a piece, or they can pay X number of dollars per month over the course of a year. If you give your owners those two options in terms of how they pay the special assessment, you also have to tell them what is the default if an owner doesn't pick one, because otherwise you are going to have a hard time knowing if and when an account is delinquent, and or it just gives the owner sort of a foothold to argue against any collection action that you might take if they don't make the payment either way. And you cannot have a range for the final payment on the special assessment. And non-payment of a special assessment is dealt with just like any other delinquency. So if you have a collection policy, follow it. If you don't, get one. I would say that if you're worried about whether the special assessment is going to pass or not, then you should be consulting with your association attorney to sort of strategize about how best to communicate with your ownership about this. If they reject the special assessment, which would require more than 50% of the voting power in the community as a whole to vote against it, so that's a pretty high bar, then you can restructure and try again, or educate your ownership on why the assessment is necessary. So if you have not yet already had early and often disclosure to the ownership about why the project is necessary, what the cost is right now, what the cost is if you wait a year or 2 years or 5 years, what the possible detriment to the building is and the additional cost that could ensue as a result if you don't do the project now. Like, give your ownership all of this information. Be transparent with them. We have worked with communities that have had much, much, much larger special assessments, like $1 million plus special assessments, where initially the owners were vehemently against the special assessment, but through a process of communication and disclosure and sort of partnering with the owners with all of this information, they were actually able to get them passed, despite the fact that nobody wants a big special assessment like that. I mean, least of all the board, right? So if you haven't been checking with your association attorney about how to help you through this process, I would recommend it. If you don't have an association attorney, first of all, get one, even if you don't need one right now. If you are working with a management company, they might be able to help you with some strategies. If you're self-managed, you could consider hiring a management consultant just to help you get through this process. So there are a lot of resources out there available to people that are going through this process. And there's a follow-up question in the chat about what to do with the leftovers. If it comes in under budget, put it in your reserve account so that you don't have to do another special assessment the next time there is a large project like this. So I think I'm going to stop talking on that one and let Jennifer take the next question.
Okay, moving on. With the new law, we believe that means 6490 creeping closer to reality. I was wondering how consents in lieu will be treated. Our board uses a lot of consent emails for projects. So what a consent in lieu means is basically a unanimous approval for whatever topic. So some of these consents in lieu.
Unanimous written approval outside of a board meeting. Sorry.
Yeah, sorry, Valerie. So the question goes on. Some have been minor, like approving minutes of meetings. Other are urgent, such as the boiler breaking and needing $50,000 in repairs. Yet others seem like they should be able to wait for a meeting. Are there basic rules governing the consent in lieu in the new environment? So short answer, and this is found under 6490 445 sub 2K. All substantive board decisions must be made during an open meeting. Consents in lieu would violate this statutory requirement unless they are for truly minor ministerial purposes. What ministerial, and that is the particular word used in the statute. What ministerial is, we don't know. But after transition from the declarant, boards can only act by unanimous consent for ministerial purposes, but every substantive decision, including repairing a boiler, getting bids, that sort of thing, must happen in an open meeting. During doing any of this particular procedure outside of owner view is not appropriate. So as we say all the time in these in the Zoom Q&As, everything must happen in front of in an open meeting in front of the owners. You cannot do email, text approvals anymore. Valerie, did you have anything to add to that?
No. I mean, I'm sure that there are people wishing that we would go into a list of exceptions, but really there isn't a list of exceptions. And even though there isn't a definition of the word ministerial, I can tell you that by its sort of plain language meaning, it means sort of administrative or inconsequential. So if you're doing something like telling the manager that they can print the minutes on double-sided sheets of paper to save money, that's fine. You can do that outside of a board meeting, right? But you should not be doing things like approving meeting minutes or getting bids for a boiler repair or any substantive decision outside of a board meeting. There is a follow-up in the chat, which is if there was an active water leak, actions can be taken to stop further damage before a meeting, correct? Absolutely. You don't like leave the pipe leaking and go, well, we got to give the owners 14 days notice of a meeting, right? Before we can do anything. And in the case of an active event that is happening, that has the potential to damage the building or the units, definitely like stop the leak, deal with any like actually urgent, time-sensitive repairs like water mitigation stuff. And then if you've got, you know, longer term, larger repair project to deal with that event, then you have to deal with that in a board meeting. But also you can call board meetings, you can call an emergency board meeting on relatively short notice, as long as you can demonstrate to a court that you did everything that you could to ensure that the ownership got notice of that meeting. So anyways, I don't want to go too far afield on that. The next question is, what happens when a unit owner does not pay a special assessment that was ratified by the association? Does the special assessment constitute a lien? What are the next steps that a board should take? And what is a typical timeline? And is any of this different if the property is owned by an estate? If an owner is delinquent for any reason, regular assessment, special assessment, any reason, you should follow your regular collection policy. If you don't have a collection policy, you should work with your association attorney to get one in place. But the short answer to all your questions is that you should handle a special assessment delinquency like any other delinquency. And it doesn't matter if the property is owned by an individual or an estate or a corporate entity for that matter. And if your if your governing documents and your governing statute provide for an automatic lien, then yes, your special assessment would constitute a lien. You asked about the typical steps. The problem is there isn't, I can't give you a typical timeline that would apply in all situations, but the steps typically include delinquency notices that are mailed by the association or your management company. We usually see them at like 30 and 60 and 90 days after the delinquency arises, including you have to send copies of the statutory pre-foreclosure notice of delinquency with those. And then if there's no response after those notices, typically that's when a file would get referred to the association attorney's office for a lien and a demand letter. And then if the owner is unresponsive, your attorney should walk you through the options that are available to you at that point, which might include small claims court, personal lawsuit, foreclosure lawsuit, if the threshold balance due is met, etc. So I think that's enough to answer the question. If you have follow-ups, feel free to put them into the chat, or more likely send them to the info@condo.law email address, and we can cover further on this next week. Take it away, Jen.
Our probably last question for today, and it's a short one. What is the best practice for a policy regarding an owner's right to be heard before assessing a fine? Should this be outlined in the declaration, the bylaws, house rules, or included in a fine or collections policy? So we recommend that having enforcement procedures in a standalone policy, so it can be updated and amended by the board as needed. This is something that only requires board approval. It doesn't require ownership approval. So having the enforcement procedures in the declaration or bylaws is well, for the declaration is definitely an extra expense because you would need to record any amendments and changes. In the bylaws, it still needs ownership approval. There was an attorney for some time who did very specific and detailed, elaborate processes for enforcement procedures and put them in the bylaws, which honestly, I don't even think an attorney's office would be able to follow these particular procedures. So if you have those, you need to change your documents, but having them in a standalone policy means that they're easier to change. They can also be in the rules. The board adopts them with notice to the ownership, and we just think it's easier to have them in a standalone policy. If it's not in any of your governing documents at all, you simply just offer the opportunity to be heard in your first warning letter or your first violation notice. Please remember that the notice and opportunity to be heard means that the opportunity to be heard is given before the fine is levied. We see this all the time. I just had a question from a management company last week where they levied the fine with the letter, and then later in the letter said you have an opportunity to be heard, contact the management company within X amount of time. That does not comply with statute. You're levying the fine before the opportunity to be heard is given. Valerie, did you have anything to add to that?
The only thing I'll add is If you don't have enforcement procedures in your governing documents, you still have to have at least a schedule of fines that was adopted and sent to your ownership in order to fine anyone for anything. So you don't have to have a whole fine and enforcement process outlined in your documents, but you do have to have at least a schedule of fines. And that takes us right up to 11 o'clock. So we are done for the day. Thank you for joining us, and we'll see you guys next week. Bye, everybody.